H. Statistics. The clerk of the circuit court shall establish procedures to determine a statistical count of all actions filed, decided, and reinstated as required by the Indiana Office of Judicial Administration, IOJA. I. Replacing lost papers. If an original pleading or paper filed with the clerk of the circuit court cannot be located within the record-keeping system set forth under this rule, the court may authorize a copy of such record to be filed and used as the original. J. Method of record-keeping. Under the direction of the Supreme Court of Indiana, the clerk of the circuit court may, notwithstanding the foregoing sections, keep records in any suitable media. Records, whether required to be maintained permanently pursuant to Administrative Rule 7D Retention Schedules, Trial Rule 77 Schedules 10, or not must, if maintained electronically, be kept so that a hard copy can be generated at any time. All record-keeping formats and systems, including case management systems, and the quality and permanency requirements employed for the CCS, the case file, and the RJO order book shall be approved by the Office of Judicial Administration for compliance with the provisions of this rule. This rule applies to court records maintained by clerks, judges, and to judicial branch agencies. K. Electronic posting of court records. The clerk of the circuit court, with the consent of the majority of the judges in the courts of record in that circuit, or the clerk of a city, town, or Marion County Small Claims Court, with the consent of the city, town, or Marion County Small Claims Court judge, may make available to the public through remote electronic access such as the Internet, those court records approved by the Supreme Court of Indiana for electronic posting. The records to be posted, the specific information that is to be included, its format, pricing structure, if any, method of dissemination, and any subsequent changes thereto must be approved by the Office of Judicial Administration, IOJA, under the direction of the Supreme Court of Indiana. Such availability of court records shall be subject to applicable laws regarding confidentiality. Rule 78. Jurisdiction pending change from county. Whenever a court has granted an order for a change of venue to another county and the costs thereof have been paid where an obligation exists to pay such costs for such change, either party to the cause may file a certified copy of the order making such change in the court to which such change has been made, and thereupon such court shall have full jurisdiction of said cause, regardless of the fact that the transcript and papers have not yet been filed with such court to which such change is taken. Nothing in this rule shall be construed as divesting the original court of its jurisdiction to hear and determine emergency matters between the time that a motion for change of venue to another county is filed and the time that the court grants an order for the change of venue. Rule 79. Special Judge Selection, Circuit, Superior, and Probate Courts. A. Application. When the appointment of a special judge is required under Trial Rule 76, the provisions of this rule constitute the exclusive manner for the selection of special judges in circuit, superior, and probate courts in all civil and juvenile proceedings. Trial Rule 79.1 constitutes the exclusive manner for the selection of special judges in all actions in city, town, and the Marion County Small Claims Courts. B. Duty to notify court. It shall be the duty of the parties to advise the court promptly of an application or motion for change of judge. C. Disqualification or recusal of judge. A judge shall disqualify and recuse whenever the judge's spouse, a person within the third degree of relationship to either of them, the spouse of such a person, or a person residing in the judge's household. 1. Is a party to the proceeding, or an officer, director or trustee of a party. 2. Is acting as a lawyer in the proceeding. 3. Is known by the judge to have an interest that could be substantially affected by the proceeding, or 4. Is associated with the pending litigation in such fashion as to require disqualification under the Code of Judicial Conduct or otherwise. Upon disqualification or recusal under this section, a special judge shall be selected in accordance with sections D and H of this rule. D. Agreement of the parties. Within 7 days of the notation in the chronological case summary of the order granting a change of judge or an order of disqualification, the parties may agree to an eligible special judge. The agreement of the parties shall be in writing and shall be filed in the court where the case is pending. Alternatively, the parties may agree in writing to the selection of an eligible special judge in accordance with Section H. Upon the filing of the agreement, the court shall enter an order appointing such individual as the special judge in the case and provide notice pursuant to Trial Rule 72D to the special judge in all parties, or appoint a special judge under Section H. A judge appointed under this section shall have 7 days from the date the appointment as special judge is noted in the chronological case summary to decide whether to accept the case. The filing of an acceptance vests jurisdiction in the special judge. An oath or additional evidence of acceptance of jurisdiction is not required. This provision shall not apply to criminal proceedings or election contests involving the nomination or election of the judge of the court in which the contest is filed. E. Reserved. Deleted, if January 1, 2013. F. Reserved. Deleted, if January 1, 2013. G. Reserved. Deleted, if January 1, 2013. H. Selection under local rule. In the event the parties do not reach an agreement or the agreed-upon judge does not accept the case under Section D, the appointment of an eligible special judge shall be made pursuant to a local rule approved by the Indiana Supreme Court, which provides for the following. 1. Appointment of persons eligible under Section J who are within the administrative district as set forth in Administrative Rule 3A or B are from a contiguous county and have agreed to serve as a special judge in the court where the case is pending. 2. The effective use of all judicial resources within an administrative district, and 3. Certification to the Supreme Court of Indiana of cases in which no judge is eligible to serve as special judge or the particular circumstance of a case warrants selection of a special judge by the Indiana Supreme Court. A person appointed to serve as special judge under a local rule must accept jurisdiction in the case unless the appointed special judge is disqualified pursuant to the Code of Judicial Conduct, ineligible for service under this rule, or excused from service by the Indiana Supreme Court. The order of appointment under the local rule shall constitute acceptance. An oath or additional evidence of acceptance of jurisdiction is not required. I. Discontinuation of service or unavailability of special judge. 1. In the event a special judge assumes jurisdiction and thereafter ceases to act for any reason, except the timely granting of a motion for change of judge, the regular judge of the court where the case is pending shall assume jurisdiction, provided such judge has not previously served in the case and is otherwise eligible to serve. In the event of the timely granting of a motion for change of judge from a special judge, or if the regular judge does not assume jurisdiction under this section, a successor special judge shall be appointed in accordance with Sections D and H of this rule. 2. In the event that a special judge assumes jurisdiction and is thereafter unavailable for any reason on the date when a hearing or trial is scheduled, the special judge may, as appropriate, appoint a judge pro tempore, temporary judge, magistrate, or senior judge of the court where the case is pending, provided such judge or magistrate is otherwise eligible to serve and has not previously had jurisdiction of the case removed from them pursuant to the rules of trial procedure, or b. The regular judge of the court where the case is pending may assume temporary jurisdiction, provided such judge is otherwise eligible to serve and has not previously had jurisdiction of the case removed pursuant to the rules of trial procedure. If the regular judge, judge pro tempore, temporary judge, magistrate, or senior judge does not assume jurisdiction under this section, such hearing or trial shall be reset to a date when a special judge is available. J. Eligibility. Any regular judge of a circuit, superior, or probate court, a senior judge, or a person serving as a full-time judicial officer in a court of record, including a person who has been a member of a panel for selection, is eligible for appointment by a trial court as a special judge unless this judicial official 1. Has previously served as judge or special judge in the case, except that whenever a court has granted an order for a change of venue to another county, the judge granting the change of venue may be appointed as special judge for that cause in the receiving county if the judge granting the change, the receiving judge, and all of the parties to the cause agree to such appointment. 2. Is disqualified by interest or relationship, or 3. Is excused from service as special judge by the Indiana Supreme Court. A special judge need not be a resident of the county where the case is pending, but accessibility should be considered in making the selection. Senior judges shall be eligible for service as special judge only in courts in which the senior judge is currently appointed by the Indiana Supreme Court to serve as senior judge. K. Appointment by Indiana Supreme Court. Upon the certification of a request for appointment of a special judge under Trial Rules 53.1, 53.2, 60.5, IC 34-13-5-4, as added by Place 1-1998, SEC. 8. Governing public lawsuits, and this rule, the Supreme Court may appoint any person eligible for service under Section J or any member of the bar of the state as special judge. The order of appointment of a special judge by the Indiana Supreme Court shall be noted in the chronological case summary, entered in the record of judgments and orders, and served on all parties in the proceeding in accordance with Trial Rule 72-D by the clerk of the trial court. Such order vests jurisdiction in the special judge, and an oath shall only be required for members of the bar appointed under this section. L. Continuation of special judge jurisdiction. A special judge shall retain jurisdiction of the case, through judgment and post-judgment, including without limitation, proceedings to enforce the judgment or to modify or revoke orders pertaining to custody, visitation, support, maintenance and property dispositions and post-conviction relief unless 1. A specific statute or rule provides to the contrary, or 2. The special judge is unavailable by reason of death, sickness, absence, or unwillingness to serve. M. Transfer of proceeding. In the event the individual selected to serve as special judge in the case is a regular judge of a court within the county and such court has subject matter jurisdiction of the proceeding, such judge may transfer the case without the assessment of costs to that judge's court for all further proceedings. In the event the individual selected is the regular judge of a court outside of the county where the case is pending and such court has subject matter jurisdiction in like cases, the parties and the judge may agree to a change of venue to such judge's court for all further proceedings. Assessment of statutory change of venue fees shall be shared by the parties as agreed or, failing agreement, as ordered by the court. N. Place of hearing. 1. Absent the transfer of the case as set forth in Section M, special judges are encouraged to employ procedures such as the use of facsimile transmissions and telephone conferences that reduce the need for travel. 2. A special judge may entertain motions and perform all administrative tasks and conferences with counsel in his or her own county. 3. All hearings involving in-person testimony by witnesses shall be conducted in the court where the case is pending unless the parties and the judge agree otherwise on the record, or b. The hearing is not before a jury and the special judge determines that exceptional circumstances exist such that the matter can only be heard in a timely fashion in his or her own county. 4. All decisions, orders, and rulings shall be noted promptly in a chronological case summary and, when appropriate, the record of judgments and the orders of the court where the case is pending and shall be served in accordance with Trial Rule 72-D. It is the duty of the special judge to effect the prompt execution of this rule. A court is deemed to have ruled on the date the ruling is noted in the chronological case summary. 5. It is the duty of the judge of the court where the case is pending to assure the availability of facilities and staff for the special judge. Emergencies. Nothing in this rule shall divest the original court and judge of jurisdiction to hear and determine emergency matters between the time a motion for change of judge is filed and the appointed special judge accepts jurisdiction. P. Compensation. A full-time judge, magistrate, or other employee of the judiciary shall not be paid a special judge fee for service as a special judge. A senior judge shall be paid a special judge fee pursuant to IND. Administrative Rule 5. All other persons serving as special judge shall be paid a special judge fee of $25 per day for each jurisdiction served for the entry of judgments and orders and hearings incidental to such entries. Persons residing outside the county where service is rendered shall be entitled to mileage at a rate equal to other public officials as established by state law, hotel accommodations, and reimbursement for meals and other expenses. Compensation for special judge services shall be paid by the state upon presentation of a claim for such services. Rule 79.1. Special Judge Selection, City, Town, and Marion County Small Claims Courts. Application. The provisions of this rule constitute the exclusive manner for the selection of special judges in all actions in city, town, and Marion County Small Claims Courts. B. Duty to notify court. It shall be the duty of the parties to promptly advise the court of an application or motion for change of judge. C. Required affidavit. In any action filed in city, town, or the Marion County Small Claims Courts, notwithstanding the provisions of Trial Rule 76-B. A motion for change of judge shall be verified and signed by the party setting forth facts in support of the statutory basis for the change. D. Agreement of the parties. In the event it becomes necessary to appoint a special judge in a city, town, or Marion County Small Claims Court, the parties may agree to the appointment of an eligible individual to so serve. Upon being advised of the agreement of the parties, the court shall appoint such individual as the special judge in the case. This provision shall not apply to criminal proceedings. A special judge selected under this section shall have 20 days to accept jurisdiction, appear, and qualify. The individual who serves as special judge under this section is not entitled to the payment of special judge fees as set forth in Trial Rule 79, J. E. Selection by court. Absent an agreement by the parties to appoint a specific individual to serve as special judge, the parties may consent to the appointment of a special judge by the judge presiding in the case. A special judge selected under this section shall have 20 days to accept jurisdiction, appear, and qualify. The individual who serves as special judge under this section is not entitled to the payment of special judge fees as set forth in Trial Rule 79, J. F. City and Town Courts. In the event it becomes necessary to appoint a special judge in a city or town court and the parties fail to agree under Section D or E, the case shall be transferred to the appropriate docket of the county, superior, or circuit court of the county in which the city or town court is located and filed without the assessment of additional fees. The judge who receives the case is not entitled to the payment of special judge fees as set forth in Trial Rule 79, J. G. Marion County Small Claims Court. In the event it becomes necessary to appoint a special judge in the Marion County Small Claims Court and the parties fail to agree under Section D or E, the procedure set forth in this section shall apply. 1. Naming of panel. Within 2 days of deciding that a special judge must be appointed under this section, the presiding judge shall submit to the parties for striking a panel of 3 judges, who, pursuant to Act 3334-5-6 must be other judges of the Marion County Small Claims Court. 2. Striking from panel. Each party shall be entitled to strike one name from the panel. The moving party shall be entitled to strike first. The parties shall have not less than 7 days nor more than 14 days to strike as the court may allow. 3. Failure to strike. If the moving party fails to timely strike, the presiding judge shall resume jurisdiction of the case. If a non-moving party fails to timely strike, the clerk of court shall strike in such party's stead. 4. Transfer of case. Upon completion of the striking process, the case shall be transferred to the court of the judge remaining on the panel without the assessment of additional costs. 5. Inability to transfer. In the event the case cannot be transferred, for any reason, to the designated special judge, the case shall be transferred to the court having the highest court identifier number, as provided in Administrative Rule 8. Of the Marion County Small Claims Court judge who is not disqualified by reason of interest or relationship, no fees will be assessed for such transfer. H. Eligibility. Pursuant to Act 33-34-5-6, no person other than a small claims court judge may serve as a special judge in the small claims court. Any regular judge of a circuit, superior, probate, municipal, or county court, a senior judge, or any member of the bar of the state of Indiana is eligible for appointment as a special judge in a city or town court unless this judge or attorney 1. Has previously served as judge or been a member of a panel for selection as special judge in the case. 2. Is disqualified by interest or relationship, or 3. Is serving as a bailiff, reporter, referee, commissioner, magistrate, or other appointed official of the court where the case is pending, except as expressly authorized by statute. I. Continuation of jurisdiction of case. In the event a special judge is appointed or a case is transferred under this rule, the special judge or court shall retain jurisdiction for all future proceedings in the case, including without limitation. Proceedings to enforce the judgment and post-conviction relief unless 1. A specific statute or rule provides to the contrary, or 2. The special judge is unavailable by reason of death, sickness, absence, or unwillingness to serve. Rule 80. Supreme Court Committee on Rules of Practice and Procedure. A. Creation, members, terms of office, and removal. There's hereby created a committee to be known as the Supreme Court Committee on Rules of Practice and Procedure, Rules Committee. The Rules Committee shall consist of 13 members appointed by the Supreme Court. All members of the committee shall be members of the Bar of the State of Indiana. The term of each member shall be for 5 years, except he had a member appointed to fill the vacancy of an unexpired term shall be appointed only for the remainder of the unexpired term. Any member may be removed by the Supreme Court. B. Officers, meetings, quorum, and compensation. Annually, the Rules Committee shall elect from among its members a chairperson who shall preside at all meetings, and a vice chairperson who shall preside at meetings in the absence of the chairperson. The Court shall assign such staff as it deems necessary for the Rules Committee to conduct its work, including preparing meeting agendas, taking the minutes of meetings, and maintaining the records of the Rules Committee. The Rules Committee shall meet monthly at a time and place designated by the chairperson, and the chairperson may call special meetings of the Rules Committee. 7 members shall constitute a quorum at any regular or special meeting. The Rules Committee shall act by a vote of a majority of the members present at any regular or special meeting. The members of the Rules Committee shall be allowed their necessary expenses and such reasonable compensation as the Supreme Court shall fix from time to time. C. Duties of the Rules Committee. The Rules Committee shall conduct a study of any Indiana rules of court assigned to them by the Supreme Court and shall submit to the Supreme Court from time to time recommendations in order to promote the just determination of litigation, simplicity and procedure, and the elimination of unjustified expense and delay. The Rules Committee shall also serve as the Evidence Rules Review Committee as set forth in Rule 1101 of the Indiana Rules of Evidence. The Supreme Court shall consider all recommendations and proposed amendments received from the Rules Committee. D. Procedure for amending rules. Except in case of an emergency or as otherwise directed by the Supreme Court, the procedure in this section shall be followed in amending the Indiana Rules of Court. 1. Submission of proposed rule amendments. Proposed rule amendments shall be presented to the Supreme Court's Chief Administrative Officer, CAO, in a word-compatible format, clearly indicating added or deleted language, and must be accompanied by the form available on the Supreme Court's website. The CAO shall provide regular reports to the Chief Justice regarding proposed rule amendments, and shall be responsible for referring the proposed amendment to the appropriate committee or other entity for further study. 2. Publication of proposed rule amendments. The Rules Committee shall publish proposed rule amendments on or before January 2, April 1, July 1, and October 1 of each year, and at such other times are necessary. 3. Comments of the bench, bar, and public. All comments on proposed amendments from the bench, bar, and public of this state to the Rules Committee shall be delivered in writing to the Rules Committee. Comments received by the Rules Committee shall be confidential unless otherwise ordered by the Supreme Court. The Rules Committee shall accept comments on the proposed amendment for a period of 30 days after publication, and may extend the period for comments. Thereafter, the Rules Committee shall study all comments received and shall submit the proposed final draft of each rule amendment, together with the associated comments, to the Supreme Court for its consideration. 4. Publication of amended rules. The Supreme Court shall be on each proposed rule amendment received from the Rules Committee and shall publish each rule amendment adopted by the Supreme Court. On January 1st of the following year, each rule amendment shall take effect unless the Supreme Court orders. Rule 81. Local Court Rules. A. Authority. Courts may regulate local court and administrative district practice by adopting and amending in accordance with this rule local and administrative district rules not inconsistent with and not duplicative of these rules of trial procedure or other rules of the Indiana Supreme Court. Courts are strongly encouraged to adopt a single set of local rules for use in all courts of record in a county and will be required to do so after January 1, 2007. The single set may reflect different practices due to geographic, jurisdictional, and other variables. Courts shall not use standing orders, that is, generic orders not entered in the individual case, to regulate local court or administrative district practice. Local and administrative district rules requiring approval of the Indiana Supreme Court or the Indiana Office of Judicial Administration (IOJA) are subject to the provisions of this rule. B. Notice and comment. 1. When a court or administrative district proposes to adopt or amend local or administrative district rules, it shall give notice to the bar and public of the content of the proposal, the time period for the bar and public to comment, the address to which comments should be sent, and the proposed effective date. Notice shall include, but not be limited to, transmitting the proposal to the officers of any local county bar association. 2. The court shall also transmit the proposal to the county clerk and to the IOJA in digital format. The county clerk shall post the proposal in the county clerk's office and on the county clerk's website, if any, and the IOJA shall post the proposal on the Indiana Judicial website for public inspection and comment. The court and the IOJA shall receive comments for not less than 30 days. C. Schedule. The IOJA shall establish and publish a uniform annual schedule, similar to the schedule for proposed Supreme Court rules under Rule 80D, for publishing proposed local and administrative district rules, receiving comment, adopting rules, and the effective date of adopted rules. D. Exceptions to the schedule. If a court finds that there is good cause to deviate from the schedule established by the IOJA, the court or administrative district may adopt or amend local or administrative district rules at other times. However, a local or administrative district rule shall not take effect unless it has first been posted for 30 days in the county clerk's office and on the county clerk's website, if any, and on the Indiana Judicial website. The court promptly thereafter shall provide opportunity to comment in the manner provided in subsection B1 above. E. Style, format, and numbering. The IOJA shall establish and publish a standard format for drafting and amending local and administrative district rules. The format shall include a uniform numbering system which, to the extent practicable, corresponds to the numbering of these rules of trial procedure and other rules of the Indiana Supreme Court. F. Adopted rules. The court shall cause adopted rules and amendments to be placed in the record of judgments and orders, shall cause the county clerk to post them in the county clerk's office and on the county clerk's website, if any, for public inspection, and shall transmit a copy of the rules in digital format to the IOJA for posting on the Indiana Judicial website. G. Availability of local and administrative district rules. All local and administrative district rules, as amended and with any appendices thereto, shall be compiled into one document, which shall be posted and available in the clerk's office at all times for public inspection and on the county clerk's website, if any. They shall be available free of charge on the Indiana Judicial website. H. Suspension of local or administrative district rules. In an individual case, the court, upon its own motion or the motion of any party, may waive, suspend or modify compliance with any local or administrative district rule if the interests of justice so require. All such waivers, suspensions or modifications shall be entered in the chronological case summary of the case. I. Transition. To continue in effect local and administrative district rules promulgated before the effective date of this rule, the court shall 1. Renumber such rules according to the uniform numbering system established by the IOIA under subsection E above. 2. Cause such rules to be posted and available in the clerk's office as required by subsection G above. And 3. Transmit a copy of such rules in digital format to the IOIA for posting on the Indiana Judicial website. By January 1, 2007, local rules must be in compliance with the terms of THIS rule. J. Periodic review and update. Courts and administrative districts should review periodically and change local and administrative district rules as required by changes in statutes, case law, or these rules of trial procedure or other rules of the Indiana Supreme Court. Rule 81.1. Procedures for cases involving family or household members. Definitions. 1. An individual is a family or household member of another person if the individual A. is or was a spouse of the other person, B. is or was living as if a spouse or a domestic partner of the other person, this determination to be based upon I. the duration of the relationship, 2. the frequency of contact, 3. the financial interdependence, 4. Whether the two individuals are or previously were raising children together. V. Whether the two individuals are or previously have engaged in tasks directed toward maintaining a common household. And 6. Such other factors as the court may consider relevant. C. Has a child in common with the other person. D. Is related by blood or adoption to the other person. E. Has or previously had an established legal relationship. I. As a guardian of the other person. II. As a ward of the other person. 3. As a custodian of the other person. 4. As a foster parent of the other person, or V. In a capacity with respect to the other person similar to those listed in clauses I through V. 2. Family procedures entails coordination of proceedings and processes, and information sharing among cases in a court or courts involving family or household members. B. Type of cases. Courts using family procedures for a case may exercise jurisdiction over other cases involving the same family or a household member of the family. An individual case to which family procedures is being applied may maintain its separate integrity and separate docket number, but may be given a common case number if multiple cases are being heard before one judge. Subject to applicable rules and statutes, the individual cases may all be transferred to one judge or may remain in the separate courts in which they were originally filed. See Notice. A court intending to use family procedures for a case must enter an order notifying all parties of the court's intention and, within 30 days after a case is selected, the court shall provide each party with a list of all cases that have been selected to be heard using family procedures. D. Designation by court of intent to use family procedures and change of judge for cause. within 15 days after notice is sent that a case has been selected to be heard using family procedures, a party may object for cause to the designation or selection of a party's case. Once notice is sent to the parties that a case has been selected to be heard using family procedures, no motion for change of venue from the judge may be granted except to the extent permitted by Indiana Trial Rule 76. A motion for change of venue from the judge in any matter being heard in a court using family procedures, or any future cases joined in the court after the initial selection of cases, shall be granted only for cause. If a special judge is appointed, all current and future cases in the court proceeding may be assigned to the special judge. E. Concurrent hearings. A court using family procedures may, in the court's discretion, set concurrent hearings on related cases, take evidence on the related cases at these hearings, and rule on the admissibility of evidence for each case separately as needed to adequately preserve the record for appeal. F. Judicial Notice. Indiana Evidence Rule 201 shall govern the taking of judicial notice in courts using family procedures. G. Court records excluded from public access. In a court using family procedures, each party shall have access to all records and cases joined under this rule, with the exception of court records excluded from public access pursuant to the rules on access to court records. A party may seek access to such confidential records from another case joined under this rule in accordance with Rule 9 of the Rules on Access to Court Records. Records excluded from public access shall retain their confidential status, and the court using family procedures shall direct that confidential records not be included in the public record of the proceedings. Rule 82. Forms. The forms adopted by the Supreme Court shall be sufficient under the rules and are intended to indicate the simplicity and brevity of statement which the rules contemplate. Rule 83. Definitions. Subject to additional definitions contained herein, and unless the context otherwise requires, in these rules. 1. Court on appeal means the Indiana Supreme Court or the Court of Appeals of Indiana. 2. Executive of a governmental organization includes the governor of the state, the officer or individual occupying any office or unit occupied only by one person, the mayor of any city or town. In the case of a governmental unit or agency headed by more than one person, the presiding officer thereof or the secretary thereof, or if none, any member thereof. In the case of a governmental corporation, the president or presiding officer, secretary, or treasurer thereof. Executive officer of an organization includes the president, vice president, secretary, treasurer, cashier, director, chairman of the board of directors or trustees, office manager, plant manager, or subdivision manager, partner, or majority shareholder. For purposes of service of process, notice and other papers, the term includes the personal secretary of any of the foregoing persons or any person employed under or with any of the foregoing persons and who is entrusted with the responsible handling of legal papers, and any person employed in the organization if such person promptly delivers the papers served to one of the foregoing. 3. Governmental organization includes the state, or a department, agency, corporation, office or branch thereof, a county, township, municipality or local governmental unit, or a department, agency, corporation, office or branch thereof, or any governmental representative named as such, or any governmental unit. 4. Governmental representative includes an officer, agent, executive or employee of a governmental organization. 5. Organization includes, without limitation, a domestic or foreign corporation, partnership, unincorporated association, business trust, governmental organization or an organization which is a representative. 6. Representative includes, without limitation, a representative of a decedent's estate, guardian, next friend, receiver, assignee for the benefit of creditors, liquidator, trustee or the like. 7. Signature or signed includes, without limitation, an electronic reproduction of a handwritten signature. Rule 84. Effective date. These rules will take effect on January 1, 1970. They govern all proceedings and actions brought after they take effect, and also all further proceedings and actions then pending, except to the extent that in the opinion of the court their application in a particular action pending when the rules take effect would not be feasible or would work injustice, in which event the former procedure applies. Rule 85. Vacated. Vacated December 5, 1995, effective February 1, 1996. Rule 86. Electronic filing and electronic service. Definitions. 1. Case Management System (CMS). Case Management System is the system of networked software and hardware used by any Indiana court that may receive, organize, store, retrieve, transmit, and display all relevant documents in any case before it. 2. Conventional filing. Conventional filing is the physical non-electronic presentation of documents to the clerk or court. 3. Electronic filing, e-filing. E-filing is a method of filing documents with the clerk of any Indiana court by electronic transmission utilizing the Indiana e-filing system. E-filing does not include transmission by facsimile or by email. 4. E-filing manager. E-filing manager is the centralized entity approved by the Supreme Court that receives and transmits all e-filing submissions between e-filing service provider (S) and the appropriate case management system. 5. E-filing service provider (IFSP). E-filing service provider is the organization and software selected by a user and approved by the Supreme Court to receive and transmit all e-filing submissions between the user and the Indiana e-filing system. 6. Electronic service (e-service). E-service is a method of serving documents by electronic transmission on any user in a case via the Indiana e-filing system. 7. Indiana e-filing system (IFS). Indiana e-filing system is the system of networked hardware, software, and service providers approved by the Supreme Court for the filing and service of documents via the Internet into the case management system (S) used by Indiana courts. 8. Notice of electronic filing (NEF). Notice of electronic filing is the notice generated automatically when a document is submitted and transmitted through the Indiana e-filing system, which sets forth the time of transmission, the name of the court, user, party or attorney transmitting the document, the title of the document, the type of document, and the name of the court, attorney, party, or other person meant to receive the notice. The time noted in a notice of electronic filing will be the time at the location of the court where the case is pending. A notice of electronic filing will appear immediately on the user's screen upon submission of the document for e-filing. 9. Public Access Terminal. A public access terminal is a publicly accessible computer provided by clerk or court that allows a member of the public to access the Indiana e-filing system and public court records. 10. User Agreement. A user agreement is an agreement in a form approved by the Indiana Office of Judicial Administration (IOJA) that establishes obligations and responsibilities of the user within the Indiana e-filing system. 11. User. User is a registered user or filing user. A filing user. E-filing users include court and clerk staff, unrepresented litigants, attorneys, or an agent whom an attorney has expressly designated to make a filing on the attorney's behalf and who has an Indiana e-filing system user ID, password, and limited authority to file documents electronically. B. Registered user. A registered user is a person or entity with a user ID and password assigned by the Indiana e-filing system or its designee who is authorized to use the Indiana e-filing system for the electronic filing or service of documents. B. User agreement required. Every user must execute a user agreement with one or more electronic filing service provider before that user may utilize the Indiana e-filing system. C. Commencement of an action. An action must be commenced 1. By using the Indiana e-filing system unless exempted by these rules. 2. By paying the filing fee unless the fee is waived by an order of the court. And 3. By filing the complaint or equivalent pleading and the required summons in the form set out in Trial Rule 4C. D. Electronic filing of documents. 1. Unless otherwise permitted by these rules, all documents submitted for filing in courts identified in the filing implementation schedule posted at http://courts.in.gov/file as updated from time to time must be filed electronically with the clerk using the Indiana e-filing system. The e-filing of documents shall be controlled by the case number in the Indiana electronic filing system designated by the user. 2. Attorneys or unrepresented litigants who wish to be exempted from the requirement that they file electronically may file a petition for electronic filing exemption. The petition must be filed in each pending case to which these rules are applicable. The petition will be reviewed by the judicial officer assigned to that case and granted only upon a showing of good cause. E. Proof of filing. Users should print or otherwise save each notice of electronic filing as proof of e-filing. Confirmation of e-filing may also be made by referring to the chronological case summary of the court in which the case is pending through the case management system of that court. F. Conventionally filed documents. Conventionally filed documents must be converted into an electronic record by the clerk or court. The filer must also conventionally serve these documents in accordance with these rules and applicable local rule and file a certificate of service. If the original documents cannot be converted into a legible electronic document, then annotation must be made in the chronological case summary and the documents returned to the filer. A person filing a will for probate shall file an accurate and complete copy of the will and an affidavit, signed under the penalties of perjury, containing substantially the following information. 1. Affiant possesses the decedent's original last will and testament, or the will has been deposited with the clerk of the court. 2. Affiant is filing a true and accurate copy of the last will and testament. 3. Unless the last will and testament has been deposited with the clerk of the court, affiant will retain the original last will and testament until the decedent's estate is closed and the personal representative is. 4. Affiant will file the original last will and testament upon order of the court or as otherwise directed by statute. G. Service of pleading and other papers. 1. Except as otherwise provided in this rule, All process shall be served in accordance with Trial Rules 4 and 4.1 through 4.17. 2. Issuance of summons and service of initial complaint or equivalent pleading. A. Except as provided below in Q. At the time the initial complaint or equivalent pleading is filed, the filer shall also file completed summons S, designating the manner of service. The clerk shall date, sign and seal the summons S and transmit the summons S to the filer for service. B. The filer shall serve the initial complaint or equivalent pleading in the summons upon all parties in the manner provided in Trial Rules 4.1 through 4.14. C. In the event of service by registered or certified mail, or other public means by which a written acknowledgement of receipt may be requested and obtained, or first-class mail as provided in Trial Rule 4. 1b. The filer shall promptly transmit to the clerk a dated and signed certificate of issuance of summons specifying the method of service with respect to each party, the date of mailing, address of each party, and tracking or identifying number for each summons. D. All returns regarding service shall be directed and made to the clerk. I. If service was issued under Trial Rule 4.1a.1, the filer shall note the case number on each return receipt or equivalent form. If service by mailing or other public means is returned without acceptance, the clerk shall reissue the summons S and complaint or other equivalent pleading for services as requested by the person seeking service. 2. If service was made by the filer personally delivering the summons and complaint or equivalent pleading to a party under Trial Rule 4. 1a.2. The served party shall execute an acknowledgement of service that the filer shall promptly transmit to the clerk. If the served party fails to execute an acknowledgement of service, the filer shall promptly execute and transmit a dated and signed affidavit of service to the clerk. 3. If service was made by the filer leaving a copy of the summons and complaint or equivalent pleading at the dwelling house or usual place of abode of the party under Trial Rule 4. 1a.3. The filer shall complete service as required by Trial Rule 4.1b and promptly transmit a dated and signed affidavit of service to the clerk. 4. If service was made by sheriff or other authorized police officer, constable or appointed process server, the person making service shall promptly make his or her return upon or attach it to a copy of the summons and deliver it to the clerk. All is provided in Trial Rule 4.15a. E. For service by publication, the filer, in addition to filing the complaint or equivalent pleading and summons S designating service by publication, shall also transmit an affidavit for service by publication to the clerk as provided in Trial Rule 4.13. The clerk shall transmit to the filer dated, signed and sealed summons S by publication. The filer shall deliver the summons S to the publication authorized by Trial Rule 4.13 C, with instructions that after the completion of the period of publication the return shall be sent to the clerk. F. When fees and other court costs are waived, and the clerk has received the required notification that the filer is entitled to this waiver, the clerk shall serve the complaint and summons S. Additionally, for service of separate or additional summons, alias summons, by the clerk, the filer shall provide documentation establishing that the filer is entitled to waiver of the fee for service. 3. Service of subsequent pleadings. Service on registered users. Registered users must serve all documents in a case upon every other party who is a registered user through e-service using the Indiana e-filing system. E-service has the same legal effect as service of an original paper document. E-service of a document through the Indiana e-filing system is deemed complete upon transmission, as confirmed by the notice of electronic filing associated with the document. Exempt parties must serve all documents in a case as provided by Trial Rules 4 or 5. B. Service on others. Trial Rules 4 and 5 shall govern service of documents on attorneys of record and on unrepresented parties who are not registered users. H. Format requirements. 1. Documents filed electronically must be formatted in conformity with this rule and the requirements of the Indiana e-filing system. 2. All documents must be submitted in the manner required by the e-filing service provider. The Indiana e-filing system may be accessed via any internet connection available to the registered user and at public access terminals located in the offices of the county clerk. I. Signature. 1. All documents electronically filed that require a signature must include a person's signature using one of the following methods. A graphic image of a handwritten signature, including an actual signature on a scanned document. Or B. The indicator /s/ followed by the person's name. 2. A document that is signed and e-filed must be subject to the terms and provisions of Trial Rule 11a. A registered user may include the signature of other attorneys in documents e-filed with the court, but in doing so represents to the court that any such signature is authorized. J. Time and effect. Subject to payment of all applicable fees pursuant to Section C. A document is considered e-filed with the court on the date and time reflected in the notice of electronic filing associated with the document. E-filing must be completed before midnight to be considered filed that day, and compliance with filing deadlines is determined in accordance with the time zone and the location of the court where the case is filed. E-filing under these rules shall be available 24 hours a day, except for times of required maintenance. K. Official court record. The electronic version of a document filed with or generated by the court under this rule is an official court record. L. Clerk processing of e-filed documents. 1. The clerk may reject an e-filing only when a. The applicable filing fee has not been paid, or b. The filer selected an incorrect case management system, or c. The filer requests rejection. 2. If an e-file document cannot be electronically processed, the clerk shall return it to the user for correction through the IFS. The user may cure the defect within 72 hours from the time of return as set out in the notice of return. 3. In all other cases where an e-file document does not conform to the IFS or other applicable rules, the clerk must process the e-file document and may direct the non-conforming document to the intended e-filing court. A court that receives a non-conforming document shall a. Strike the non-conforming document, or b. Issue an appropriate order. If the court's order allows a party to cure a defective e-filing, the party has 72 hours to cure the defect. 4. In the event a user submits a cured document within 72 hours, excluding days the court is closed, the document is timely filed. M. Certain court records excluded from public access. 1. Procedures for excluding court records from public access. Any user filing a court record that is to be excluded from public access must do so in accordance with the following procedures. A. Notice to maintain exclusion from public access. I. In cases where the court record is excluded from public access pursuant to Rules 5 or 6 of the Rules on Access to Court Records, The party or person submitting the confidential record must provide the separate written acre form required by the rules on access to court records identifying the specific access to court records Rule 5b, 5c, or 5d ground s upon which exclusion is based. See Rules on Access to Court Records Form Acre. 2. In cases where all court records are excluded from public access in accordance with Rule 5a of the Rules on Access to Court Records, no notice of exclusion from public access is required. B. Public access and non-public access versions. Where only a portion of the court record has been excluded from public access pursuant to Rule 5b, 5c, or 5d of the Rules on Access to Court Records, the following requirements apply. I. Public access version. If a document contains confidential court records to be excluded from public access, that confidential court record shall be omitted or redacted from this version. B. The omission or redaction shall be indicated at the place it occurs in the public access version. If multiple pages are omitted, a separate placekeeper insert must be inserted for each omitted page to keep PDF page numbering consistent throughout. C. If the entire document is to be excluded from public access, the Access to Court Records acre form filed with the document will serve as the public access version. 2. Non-public access version. If the omitted or redacted court record is not necessary to the disposition of the case, the excluded court record need not be filed or tendered in any form, and only the public access version is required. The Access to Court Records acre form shall indicate this fact. See Rules on Access to Court Records Form Acre. B. If the omitted or redacted court record is necessary to the disposition of the case, the excluded court record must be separately filed or tendered as follows. 1. The first page of the non-public access version shall be conspicuously marked "Not for public access" or "Confidential," with the caption and number of the case clearly designated. 2. The separately filed non-public access version shall consist of a complete, consecutively paginated replication including both the public access material and the non-public access material. 3. Use of green paper is abolished for e-filing. Pages in the non-public access version containing court records that are excluded from public access shall instead be identified with a header, label, or stamp that states "Confidential per Rules on Access to Court Records" or "Excluded from Public Access per Rules on Access to Court Records." 3. The requirements in Rule 86, M1b do not apply to cases in which all court records are excluded from public access pursuant to Rule 5a of the Rules on Access to Court Records. 2. E-filing document security code settings. Where only a portion of the court record has been excluded from public access pursuant to Rules 5b, 5c, or 5d of the Access to Court Records rules, the e-filing document security code setting for the public access version shall be "Public Document." B. Where only a portion of the court record has been excluded from public access pursuant to Rules 5b, 5c, or 5d of the Access to Court Records rules, the e-filing document security code setting for the non-public access version shall be "Confidential Document" under the Rules on Access to Court Records. C. In cases in which all court records are excluded from public access pursuant to Rule 5a of the Access to Court Record rules, the e-filing document security code setting shall be "Confidential Document" under the Rules on Access to Court Records. N. Inability to e-file. 1. Indiana e-filing system failures. A. The rights of the parties shall not be affected by an Indiana e-filing system failure. B. When e-filing is prevented by an Indiana e-filing system failure, a user or party may revert to conventional filing. C. With the exception of deadlines that by law cannot be extended, when e-filing is prevented by an Indiana e-filing system failure, the time allowed for the filing of any document otherwise due at the time of the Indiana e-filing system failure must be extended by 1 day for each day on which such failure occurs, unless otherwise ordered by the court. D. Upon motion and a showing of an Indiana e-filing system failure, the court must enter an order permitting the document to be considered timely filed and may modify responsive deadlines accordingly. 2. Other failures not caused by the user who was adversely affected. When e-filing is prevented by any other circumstance not caused by the user who was adversely affected, the user may bring such circumstances to the attention of the court and request relief as provided in Trial Rule 6b. Or the user may revert to conventional filing. O. Appearance form in e-filed cases. In all e-filed cases, the parties shall file an appearance as provided in Trial Rule 3.1, with the following modifications. 1. The appearance form shall omit the statement contained in Trial Rule 3.1a.4 regarding acceptance of service by fax or by email. 2. The appearance form shall contain a certification that the contact information listed on the Indiana Supreme Court Rule of Attorneys for each attorney is current and accurate as of the date the appearance is filed. B. Acknowledgement that orders, opinions, and notices, and all documents served under Trial Rule 86G will be sent to the attorney at the email address S on the roll of attorneys regardless of other contact information supplied by the attorney, and C. Acknowledgement that each attorney listed on the appearance is solely responsible for keeping his/her roll of attorney's contact information accurate per ind. Admis. Disc. R2A. See Form 86-1. P. Reserved. Q. Protection order cases, workplace violence restraining order cases, and child protection orders, issuance of summons and service of petition, an ex parte order or equivalent proceeding. 1. The Protection Order Registry e-filing service provider (POIFSP) is the only provider for e-filing of all initial complaints or equivalent subsequent pleadings and all subsequent filings for civil protection orders and workplace violence restraining orders (PO case types) and for requests for child protection orders (JQ case types). 2. Where service of process is required by Trial Rule 4.1 through 4. 16. For any document filed in or issued by the court in a civil protection order or workplace violence restraining order case (PO case types) and in a child protection order case (JQ case type), that service must be accomplished by the clerk, a sheriff, court official, or other person appointed by a court to complete service of process. Appendix: a schedule and format for adoption of local court rules, pursuant to Trial Rule 81. ANA. Adobe PDF. Appendix A1: request for approval of local rules. ANA. Adobe PDF. Appendix A2: affidavit of debt. Microsoft Word. Adobe PDF. Appendix B: appearance by attorney in civil case. Microsoft Word. Adobe PDF. Appendix C: guardianship registry information sheet. Microsoft Word. Adobe PDF. Form 86-1 e-filing appearance by attorney in civil case. Microsoft Word, Adobe PDF.